Welcome to Financial Estate Literacy. It's your estate. And Pete, why don't you go ahead and introduce Mark? And I'm going to go away. So if you have questions, click on Q&A and I will respond to them. And we will then go through those. If there are questions, I'll come back as the questioner and I'll either answer them or we'll be back. So tag, you guys are it.
All right. Welcome, Mark.
Hi, Pete.
Let's see. First of all, this is Financial and Estate Literacy. We're a not-for-profit 501c3. Our purpose here is to educate the public on estate planning, financial planning, and charitable planning. So none of us here are going to be making any money from this presentation. So what we ask you to do is that this is all about you, and hopefully you can give us feedback whether or not what we're doing in educating you is working. One of the other things is that we ask all of our presenters to complete an Ask First form, and that gives us a little bit of a history as to their background. So, Mark, your background, you've got a master's or other advanced degree. What is that in?
It's my law degree.
And by the way, not only do you have a law degree, but you are certified and you're an Aztec. What does those things mean?
Sure. So certified specialist, that's something that you can do through the state bar after you've been practicing for about 10 years. You sit for a whole new bar exam and it's focused on one particular area. So I did this many years ago and I'm certified as a specialist in estate planning.
Go ahead and bring yourself back up, put the Ask First form away, but let's continue talking about it.
All right. How's that?
So
being certified as a specialist is just another bar exam, basically, that you take. It's a whole day test. Your answers get sent to a bunch of other certified specialists, and they decide whether you seem to know enough for the state bar to call you a specialist. And AgTech, is that what you wanted next?
No, yeah. What is it?
So AgTech is
social club.
It's a what club?
A social club.
Right. It's the American College of Trust and Estate Council. So it's a national organization of estate planning attorneys, and getting into it, you're voted in. Some of your peers across the country have to decide that you should be a member of this, and they nominate you. And then the membership committee, actually the whole college, which is about 200 people in California, so not that many, and about 2,000 across the country, have to vote on whether you've written good scholarly articles, whether you've been presenting at sort of the top national seminars and teaching other attorneys how to do estate planning.
It's a real honor to be an Aztec fellow, and I didn't mean to make fun of it, but
no, not at all.
No, it's you've handled estates from as small as 10,000, and you handled estates up to $1 billion plus. And so you are well qualified. Today, you could literally give the lecture for the entire series. But what we try to do is that expose the audience to different attorneys, because this is a 6-part series. And so this is just the introduction. And so one of the things that we want to do is, as well as introduce different types of estate planning attorneys. So one of the things is that in your particular case, you're certified, you're an Aztec fellow. How do you charge your clients for your services?
For regular estate planning, like a trust and a will and all the stuff that we'll overview today, I can charge by the hour. Sometimes clients seem to like a project fee, so they know this is what it's going to cost from beginning to end. And after we've talked for a little bit and I get an idea of what a client wants, I just set a project fee. And
okay, let me give you an example. I've got 500,000. I've got 2 kids. I'm married. I have a brokerage account. I have a bank account. I have a nice car, and I own a home here in Laguna Beach. Approximate worth is $2 million. What would you charge? And I'm a nice guy, and you know me.
You're a nice guy, all right. And you're not telling the bar that I'm talking
Yeah.
about fees online. That, probably my starting place is around 3,000.
Okay,
And then it just goes up depending on how much complexity we need. So sometimes it hits, 6,500 or something like that, if somebody's doing a lot of tax planning.
okay. So somebody would, do you charge for the initial consultation?
Nope.
No.
I,
No charge on the initial consultation, so they can give you a call or meet with you, and then you would give them an idea as to what the cost would be, and then you could go on from there.
Right.
Is that correct?
That's it.
Okay, so the process, what's your hourly rate?
$695.
Not 700.
Not so under 700.
Okay.
But I had to, yeah. In my last firm I was at, it was well over 1,000. So when I went out on my own, I thought I've got to scale it back to a reasonable thing.
Well, you've been with some pretty major national estate planning law firms, so you've got a lot of good experience. And I think the project fees are, people can understand a little better, so I think that makes it more comprehensible and affordable.
Yeah.
Okay.
I think people really like it.
Yeah, I do too. You're our first speaker, and so you're going to give us an overview of estate planning. So why don't we get started, Mark?
All right, let me figure out how to share this screen now.
Oh, by the way, Mark's office is here in Laguna Beach on Glen Eyre, and just recently moved there. So I don't know if your website is up, or
The website,
how they would contact you.
yeah, the website's up.
Okay.
The last screen of this has got my phone number and email, so
Okay.
everybody will have that. So, yep.
You
Anybody who
and you
wants-
readily take emails and questions, right?
Yeah.
Okay.
Yeah. So one of the things I've done, and I don't want to spend too much time on it, I'm structuring this practice, because remember, I just opened my own office 30 days ago.
Yeah.
Yeah, I'm slowing it down. I want people to be able to call me and ask questions and not take 4 or 5 days to get back to people. It's just not fun for anybody.
Okay. I love that quote. Leonardo.
Yeah. Leonardo, yeah. Coco Chanel said something like this too, and I put that up here, and the website designer said, I think that's not Coco Chanel. So yeah, simplicity, the ultimate sophistication. One of the things that you will hear me say through this presentation, and if we ever were to talk separately, the simpler we can keep your plan, the better, because it gets so complex. And when somebody becomes incapacitated or passes away, it just feels like the world crumbling in, and I don't want to put more complexity into that situation.
I wish more attorneys had your philosophy, because I've seen 60 to 100-page documents that nobody can't even stand to pick up, much less read.
Right.
So,
it's like your workout.
Yeah, exactly.
Yeah. All right. So should I just sort of keep going?
Yeah, get going.
So for everybody here, if you have not seen a lawyer, done something to create your own documents, you already have an estate planner. And this is it. There's Gavin Newsom up there. He is the person, the state of California has a set of rules that apply to every resident in the state. So that's not always great. Because it's sort of built to averages, and a lot of people have specific things they want to accomplish that the default plan doesn't accomplish. And we'll talk a little bit more about what that default plan is, but just wanted to, right from the start, say that pay attention to this in the next 6 weeks, because you want to get out of this default system. You don't want to have the supply.
I think everybody has a desire to have an estate plan, but I think the procrastination, it keeps on putting it off until finally, maybe at 85 and 90, I said, I do need to do this.
Right. Right. No, it's not easy to talk. And I would say as we talk a little bit about how do you pick your attorney, that's one of the most important things, is to feel like you can sit across the table or wherever with the person that you've hired and feel comfortable talking to them about things. You don't want to feel like they're talking over your head or that they're throwing legalese at you. If you don't understand something, stop it and say, I don't
Ask
understand that.
questions.
Yeah, ask questions. Yeah. All right. So here's an overview of the default plan. We're going to come and go from this particular screen. So you can see we've got three things up here, four really: medical decisions, dealing with assets, minor kids, and the distribution of your estate. Right. So let's just start with this primary question of what happens if the meteor comes from me and it doesn't actually take me out. It makes it so that I can't make decisions. I've lost my capacity to understand difficult things. I may not be able to communicate, whatever it is, right? So the first thing that we think about is who's going to make healthcare decisions for me. And that's the first thing I'd think about if I can't do it. And so you can see at the bottom, the answer is the court's going to appoint a conservator of the person. So what does that mean? When I walk into a court or somebody walks in for me, because remember at this point, I'm incapacitated. So somebody is going in and saying to the court, we need to be able to control Mark's assets and make medical decisions for him. So the court's going to see two things. They're going to see the dollars, the assets, the things that I own as one type of skill set and one type of job to give out. And then they're going to see on the other side of the screen, me personally, physically, where I am, what kind of treatment am I getting? What are the doctors doing? Withholding treatment if it doesn't seem to be appropriate. So there's two totally different skill sets, right, between managing money and making these sort of where are you living and what's happening to you physically decisions. So the court will look at the person who's going to make healthcare decisions for me, take care of my body and my physical location and where I live. All of those things is going to be the conservator of my person. And the person who gets in charge of my assets is going to be called the conservator of the estate. So the courts will see this differently. And when we're talking about making medical decisions, they will appoint, as the screen is first slide shows, first to the left shows, a conservator of the person for me. If the court determines that I also can't manage my own assets, then the court's going to appoint a conservator of the estate for me. Conservatorship, I don't know, we can't see a show of hands, but conservatorship is one of the most horrible things that you can go through. Yeah. Because the court has stripped you of all rights to make decisions, of all rights to participate in your life. What's the most famous one of these that we've heard of lately? Right? She couldn't decide where to live. She couldn't control her money. She got an allowance. She couldn't get married. She couldn't have kids. So it's a terrible sort of experience to go through. And it's not just terrible for the person who's in it. It's also, so on the, I guess that would be the right side of the screen. So that's her dad, who was her conservator. And it's a terrible thing to go through as the conservator too, because you've got a court watching everything you do. You've got paperwork that's due every year. The court can call you in at any time and tell you to do something differently. If you decide you want the court to help you make a decision, it's a petition process. It's weeks on end. So it's not fun for anybody who's involved in this. So we want to stay far away.
Yeah, and you have some kind of, particularly this case, one of your law firms that you worked for previously was intimately involved. So you saw it firsthand what a mess it can be. And for the common person, it's the same. It's not just a celebrity. Right now, to get into court here in Orange County, it would take you 4 to 6 months. So, it's just.
And what's happening in those 4 to 6 months?
Oh, yeah.
Nothing.
So what documents should someone, so what point I'm getting to is that you're saying this estate planning is not about death.
It's about life.
Yeah.
To
But,
me, you
but
gotta
Mark, let me ask a question. And there's been a question about this. I'm married. Isn't my spouse going to take care of all this? Of course, that assumes we didn't die together or incapacitated together. But
yeah, assume that you didn't die together, that one of you still has capacity. There is a preference, and we'll talk about this preference in greater detail a
Okay.
little bit later.
okay, thank you.
There is a preference for spouses and family members to take over these jobs.
But it's not automatic.
It's not automatic. You can probably go in and talk to a doctor about your husband or wife, without a healthcare directive. But once your spouse becomes incapacitated, the doctors tend to really slow down because now they're worried about who's going to sue them.
And under HIPAA rules, it gets real sensitive. I remember going to a doctor one day with my wife was there, and I asked about a condition, and she looked at my wife, and I said, "I release you of HIPAA requirements." And she goes, "Thank you." Okay, blah, 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 and off went the discussion. She wasn't even talking about my wife, and I thought that's interesting. We were talking about my eye.
Right. Right.
Yeah.
Okay.
Yeah.
All right. We'll come back to it.
Okay.
Thank you.
All right. So let's hit these last two, and then Pete will go to what do we do instead?
We're going to spend till we have an hour and a half for the entire program. So we will go, and Dawn will help us keep track of time. So we have, I think, a good hour still. So.
Okay. Yeah. All right. So we'll just keep going. So we've talked about, I wanted to say, when you said this isn't just about death, when you think about your estate plan and you're deciding what to put into it, the first law firm I worked for told me that we need to create plans that work. And that means that when somebody becomes incapacitated or somebody dies, if they could look back and see, all right, the right people are making the right decisions, they're the ones I wanted, then we've got a plan that works. But it's not just death. There's very much a focus on what happens to you as time goes by. So here's another thing that could happen to you. You might not be able to raise your minor kids till they turn 18, right? So if you become incapacitated, I had a client who had a terrible experience out hiking, not at Laguna Canyon Foundation. And a rock slide happened, and one of the rocks crashed into her head, and suddenly that morning she had 2 kids that she was primarily the caregiver of in the afternoon, and ever since she hasn't been able to participate in that. So the court will do the same thing. It'll appoint a conservator of the estate and a conservator of the person of the kids. Now, if they're minors, they will call it a guardianship instead of conservatorship, but just the same ideas apply, that if you can't raise your kids, the court's got a way for dealing with that. And we're going to talk about ways and steps you can take to avoid all of these court decisions, but just to get that out there is another thing. And then finally, you see 1 out of the 4, that's the only one that talks about death. And it's what happens after you die. Where do your assets go? If you haven't given any decisions or given any directions, then probate and intestate succession rules are going to apply. So what's intestate succession? That's the default rules that apply to you under state law. And it's not just California. All states have some sort of intestate succession statute. But ours in California is pretty developed. Our probate code is old, relatively speaking, which means we've got a lot of case law and a lot of history in the courts.
A lot of rules.
A lot of rules. Yeah. Yeah. So, for example, courts will tell you if you leave assets to one of your minor kids, they don't get it. Nobody can touch it. We're going to lock it away in a blocked account and say that when the kid turns 18, they can come back and ask the court to release their funds. So it's not a great succession rule.
Plan. No, even it's that people don't realize that when they put their grandchildren in their will or trust and give them gifts outright to minor children.
Right.
It's a problem.
Exactly. Yeah, exactly. There should be something else in there that avoids this.
By the way, we will talk about that in future sessions, but that's just something to keep track of if you've named grandchildren in your estate plan.
Right. So what are the things you can do instead? Well, hold on. Let's finish up the probate idea. So is probate really all that bad? Here are some things we want to think about. It's a court proceeding, right? And as Pete just said a few minutes ago, to get the court started on anything, especially in Orange County, it's 4, 6, 8 months before the court will even take a look at your papers.
Yeah, it's COVID. It's employee changeover. It's lots of factors, just besides the fact that probate is a very meticulous process.
Yeah, it's full. They've tried to make it simple by creating forms that you use in every single probate. So the judges and the attorneys who work for the courts can go through and look at things. But it is really simple. If you're working with an attorney who hasn't done a lot of probate, they may not understand what some of these little boxes that they check are. And the court attorneys, we call them clerks, but they're really attorneys, will stop it and say there's a box that should have been checked and wasn't, and that means that they don't go any further really in the process.
They go to the back of the line.
Yeah. So, and then you got to figure out what box didn't I check, or what should I have said, and file again.
Yeah.
So it's just a terrible process. So when
you say it's a terrible process, and I agree with you, but we're changing title to assets that could be hundreds and millions of dollars. So, and I don't know anyone who doesn't want somebody else's estate.
Right.
Right. So it's almost a built-in resistance for this process to occur.
Yeah. When you start a process like that, the court will actually set a deadline on when they think you should be finished. And depending on the county, it's either 15 months or 18 months out.
I have one that's going on for 12 years.
Oh my gosh. Yeah.
So
they think you should make some kind of progress between 15 and 18 months. And then obviously you get these things that go on forever.
Yeah.
But if you're thinking that you can just start probate and get through it in a few weeks, no, that's not how California works. In other states, it's actually pretty fast, but we'll talk about why California probate may be a good thing in some circumstances. But let's keep going. So let's say the other thing you want to think about is the expense. So the fees for the attorney who's going to help you take something through probate court are set by statute. And here this slide sort of plays it out, what the fees are. So if you've got $500,000 that ends up having to go through probate, the statutory fees for the attorney are about $13,000, and the executor, who's the person dealing with the court and all the paperwork and all the filings, also gets $13,000. So that's $26,000 out of your $500,000 going away in fees, which is, we talked a little bit about how I charge for doing estate plans. So you can see that it's much, much cheaper to come and get your estate plan done than to let this go. Because what if you get up to $1 million? Then it's $23,000. Everything over that, over the $1 million, is charged at 1%. So I think the biggest probate I've ever dealt with from start to finish ended up with fees being about $275,000. That's a lot of money that could go to beneficiaries instead. There are some things that these statutory fees don't cover. This fee schedule is meant to cover the basics of filing your probate, getting it through the system, and getting an order. And that's the thing that you want at the end, is an order telling you where these assets should go. But if you sell a house,
Mark, a couple of questions. First question is, okay, for instance, your $500,000. So my house is $500,000, but I have a $400,000 mortgage. So I really only have $100,000, right?
Great point. Nope. Not in the probate court size.
Yeah.
Yeah. And probate, these are gross numbers down the left column.
Right.
So if your house is valued at $500,000, and how do you know that? The court will appoint somebody to tell it what the value is of every one of your assets.
Okay. On your previous slide, there was a Hegstead petition.
Yeah, we're going to come back to that slide.
Thank you. Okay, Thank you.
Yep. I just wanted to keep it to, so we thought expensive,
Okay,
we thought 18 months. Now I want to think about public. Everything that gets filed in a probate is open for inspection. You can go right down to the courthouse, go to the clerk's office. They've got computers for you to use. You can look up everything that gets filed in a probate. Now, sometimes people will ask a judge to make something confidential so you can't find it, but the default is that everything is public. So I can go down there and I can look up anybody who died. I can find out what do they own, what were their debts, who were their beneficiaries, what did they get. It's information that you really don't want somebody in the public to just be able to go find. So eventually we'll talk about how we get away from probate. But these are just is a probate really that bad? And then because it's public, it's an open form. So if there's anybody in your life who thinks they should have gotten more or they should have gotten something and you didn't give them anything, they're already got a court. They've got a judge sitting there. They've got a case number. They can file anything under, and you're right there stuck with a judge looking at every kind of thing that comes in from a third party. So it's an open forum. Again, you don't want that. So two more parts about about probate being bad. First is, what does the intestate succession rules actually say? So the rules look kind of like a tree if you could divide them up. If you could diagram it out. So the rules would say, if I die and I'm married, my spouse will become my primary beneficiary. If I don't have a spouse, but I have kids, they become the primary beneficiary. Then we just keep looking down the line. If there's no spouse, no kids, no grandkids, and nobody else down below, then the branches go back up and out, and we look for my parents, and then we look for my siblings, and then we look for my nieces and nephews, and it just keeps branching like that. So intestate succession is probably not the plan that most people would pick. And in California, we have a wrinkle because California is a community property state. So we have community property issues and separate property issues. For community property, the default is that 100% of that will go to the spouse. And that's kind of what everybody expects. If you own something jointly with your spouse or you bought it together, then it probably should go to the spouse. What about separate property? So if I have separate property, which means somebody gave it to me, I inherited it, or I bought it and had it before we got married, then it's my separate property. Separate property does not automatically go to the spouse. Under intestate succession, it will get divided up between the spouse and your kids, which is also something that many people don't want because they do want it to go to the spouse, but our intestate succession rules don't say that about separate property. And how it gets divided up, it just depends on how many kids I have. But the spouse will probably get a half or a third, not all of my separate property. My kids will get some of it. So a couple of alternatives that are statutory. These are things that you would have to do after death. It's not the same as taking control during your life and putting your own plan in place, but just to say that, maybe sometimes you don't have to go through the full probate process. California's got 3 ways of doing that. First, we have a small estate affidavit, and the courts have decided that there's a certain limit and they don't want their calendars clogged up with matters that are small in their minds. And so it changes almost every year. This year it's $184,500. So if you've got assets that are under $184,000, then we can move them with a simple 2-page affidavit process. We still get a court order, and that's what we want, but it's a simple process. That $184,000 does not include real estate. There's a separate limit for real estate. It's only 50 grand. And I don't know, Pete, have you seen many properties in California that
Not even a garage,
That's your front steps. Yeah, we can move those. Yeah. So the small estate affidavit process is really something that we use when we we find an asset that got left out of the other plans. But it's not something we want to rely on. So here's the next choice, spousal property petition. If I die and my spouse is supposed to get all my community property, and based on the fact that I have 2 kids, my spouse is going to get 1/3 of my separate property. So the spouse can go to court and file a pretty simple petition, meaning it's 10 pages instead of 50 or 60, and get an order within maybe 9 months, 8, 9 months, something like that, that says all of these assets listed in this petition are going to go to the spouse. So the spouse doesn't have to go through that full 15, 18 month, or in Pete's case, 12-year process. There's a simpler process for spouses to go through, but it only works for spouses. It only works if you're married and living together and not legally separated at the time that the first spouse passes away. It's funny that I have to say that, but I have to, because more and more times I'm finding clients who are legally separated, and they just haven't gotten divorced for one reason or another. And it's a real mess, because if you're legally separated, from the probate point of view, you're still married. And so your spouse, even if you haven't lived with them for 10 years, is going to get this.
Yeah, there's a lot of family law and probate crossover in this area, and especially with second marriages, third marriages. So people thinking that there's a common law marriage, same-sex partners, there all sorts of issues with in how you own the property, and we haven't even gotten to title yet. So
Right. All right. So we've got to keep going.
Hegstead, what is that?
Hegstead. So Hegstead is a petition that you can try to use with the court if you're not a spouse. Right. So if you're a spouse, the spousal property petition is easy. If you're somebody else and you can show that you are the heir, that you're the beneficiary of the assets, then you can try a Hegstead petition. It's a weird name. And it was, when it came around, it was kind of changed the game in California. I think it's been in place since the mid 90s. Hegstead just says there's enough evidence here that this asset should go to this person, that we're not going to require probate. Now, the case itself in Hegstead dealt with a trust and property that had gone into the trust as the trust was created, as it should have, and then came back out during a refinance. And the bank never put it back into the trust, which happens all the time. Even if you do your estate plan, you've got to be careful and thoughtful about how your assets title sits over the years. But Hegstead was a way for the court to say, no, there's enough evidence here. It was in the trust. It came out for an obvious reason, that that it didn't really mean they were trying to change title. So the court put it back into the trust without a full probate.
By the way, we spent most people think that everybody has a trust, and the vast majority of people do not. And so the vast majority of people are going to be subject to probate. It's as much as you hear around, this is what happens to the majority of folks.
Yeah. Yep. It's still surprising. The statistics are kind of terrifying. How many people don't have any plan at all, except this default one.
Yeah. Let's go to the next slide. Don has a question.
So somewhat on the point that you just made, Pete. So the question is, there's no will and no trust. I'm married, have been for a while. All of the money accounts, if you will, are on beneficiary statements to the spouse, and the home is jointly owned, and I'm going to assume community property in this case. Do they still have to go to probate, or isn't it all theirs anyway?
I think
we're going to cover
petition.
Yeah, we're going to cover that if we can hold on that question in a bit. Okay,
then I'll ask the other question while we're here.
All right.
I think we should have an estate plan, and my spouse doesn't. Can I do a half a plan?
Yeah, sure.
Okay.
You can control
You'd have to split
your
the property, though, wouldn't you?
Yeah, you can control your separate property.
Okay,
And you can make decisions about where your community property goes, but if you give it to anybody other than your spouse is going to have to say, I agree with that.
thank you.
As it should be, by the way.
Yeah, right. So is there anything good about probate? All right, so we got three things here that are actually, I think, good. First of all, is creditors. California's process is very old, and its thought process says when we finally get to giving assets to the beneficiaries, we don't want anybody to come knocking on the beneficiary's door saying that actually belongs to me. Right. So when you make it through a California probate, you're in pretty good shape if you're a beneficiary, because creditors will have gotten cut off. When you start a probate, one of the very first things that happens is you put notice out there. You say, anybody who thinks, if I died, if anybody who thinks Mark owes them money, you've got a short period of time to come forward and put a claim in.
I've made this recommendations to people who have had long bouts of cancer treatment or medical treatment.
Medical
and they've
bills.
just have built up with credit cards, medical bills. Their creditors are are higher than their assets. And so just to cut them off, we go through probate.
Yeah. Yeah. And there's it is a very powerful thing to be able to cut off the creditors.
Well, and if you just have a living trust, what is the creditor time period?
The probate code cuts the creditors off and they're barred forever. In a trust, the trustees should do the same thing. I mean, there's two ways to do it. You can either just issue notice to known creditors and cut them off.
But I think it's 1 to 3 years, as my understanding.
Yeah. It's not short.
It's not short. Yeah.
No, in a probate court, this is like a 120 day to 150 day kind of process.
Yeah.
And that's a pretty short time for a creditor to get it together and file the claim.
But beneficiaries are never responsible for the individual's debts.
Right. At the end of it, if the creditors outweighed everything, then there's just no estate left to go to the beneficiaries. Right. And if you do have a trust, your trustee can elect into this creditor process without starting a whole probate, but they can elect to follow this notice period in the probate code.
Very few attorneys know that.
Yeah. But it's a really smart thing to do. I mean, you do have to file something in court, to get the process started, but I think it's totally worth it.
Yeah, if you have creditors out there, let your attorney know. You need to let all your financial information and about your family. Your attorney needs to know this stuff in order to develop a good plan. It's not just a cookie cutter approach. What do you mean by aid to personal representative?
So this means in a nice way that your personal representative can't screw it up, because the court is going to stop the process at any point where it feels like something's not happening the right way, some paper didn't get filed.
So you're talking about the trustee, executor, personal representative.
Right. And we use those names sort of interchangeable. For the person who's dealing with your assets in front of a court, they'll either be your executor or your administrator. And it just depends on the facts in play at the time that you die. Generally, we call them a personal representative because it covers both of them, but it can apply to your trustee. However, in this case, a trustee will not have a court guiding them. So so this particular point really doesn't apply to trustees. Yeah. But the process is very complete. The paperwork it's all judicial council forms. You can go on the website, you can download everything. And then the court approves everything, so that if you are the person taking assets through this process, when it's all done, you have no hanging liability for anything that you did. Not the same necessarily if you're dealing with a trust. So sometimes probate is better. And then of course, the last one, it reminds the personal representative of their fiduciary duties. which you can boil down to, there's 12 or so of them laid out in different probate code sections about the duty to be impartial to the beneficiaries, the duty to be loyal to the documents, all that kind of stuff. But really, you boil it all down to communicate, communicate, communicate. Tell the people who are involved what's going on, tell them regularly, because then it's hard for anybody to say that you were behind the scenes scheming. If you're really keeping everybody informed, it goes a long way.
And by the way, this is also for trust administration. Whoever
Absolutely.
you select as a trustee, let them know they need to communicate, 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 because if you don't communicate, everybody thinks the worst, and it's
Right.
about money. And then
Yep.
there's about the pillow talk, you know, during this process. So communicate is just, I love that you put that on there, Mark, because it's so important. Don,
Does my personal representative have to live in California if this is a California, I die in California?
Okay, good question. Your personal representative has to be a US citizen, but they don't have to be a California resident. So you could have somebody in New Hampshire or someplace like that be your personal representative. However, the courts don't like it if you don't have a California resident as the executor, administrator, personal representative. And that's because if I name my brother who lives in Georgia as my personal representative, California courts have no authority over him, right? So if he decides to abscond with all of my money, the California courts aren't going to have a real way to control him because he's not
a resident.
of California.
Yeah. And it makes
So
it really awkward.
It's a long way to go. Yeah, it really does. And it's a long way to go. And courts do want to see the personal representatives every now and again show up in the courtroom because it, shows the judge that they're doing the right thing. So the courts will say if you don't have a California resident, they have to post a bond. And that's the way the courts feel comfortable. So if my scoundrel brother in Georgia does take all of the assets, he will have had to buy an insurance bond that says, here's the value of the estate. If I take it all, right, the insurance company is going to come in and pay the beneficiaries.
Yeah. And he can't use a Georgia attorney. He has to hire an attorney here in California.
Right. So for him, that's going to be a big process to try to communicate back and forth. And he'll be sitting around talking about this with other people, and they'll say, what are you talking about? When my mom died, it only took us 8 weeks, to do this in Georgia.
Is every state different, has different rules regarding probate?
Yep. Every state's different.
So
The big thing the biggest thing that I like about California probate is this creditor barring, because in other states, like in Georgia, you can get through a probate in 12 weeks. But the creditors can follow the assets to the beneficiaries, which is, that's what that process is. But I like
creditors love that. Yeah.
So,
And by the way, when we talk about creditors, a lot of times we're talking about credit cards. And once you miss a payment or anything else, all of a sudden it goes to 35% compounded. So we're not talking about small little, hey, Joe borrowed some money, although that can happen. We're talking about major corporations that are trying to go after you.
you have legal departments set up to scour the papers, looking to see that one of our people died.
This is not, it's a David Goliath kind of thing.
Let me go back to the personal representative, because I want to make sure we didn't mislead somebody. If my personal representative, if I'm going into probate, I should have a California personal representative. If I simply die with a will and a trust and everything's great, they can still be my executor and live in Georgia.
Okay, so
I'm no longer in probate. Now I am a outside estate.
So if you have a will and you need to get the will, and you need to get an order from the court dealing with things like title to California property or title to bank accounts that are in California, your personal representative, your executor. Okay. So let me talk about executor versus administrator, since this came up. So if you die with a will, then the person who's going to interact with the court is called your executor. If you die and you have nothing in place and you're using this default probate intestate succession plan, then the person dealing with the court is called your administrator. So I don't know why there's two different words, but they're two different words. There's still the person dealing with the court. So if you do an estate plan and it's got a trust and you are good with getting your assets in there and keeping the title right.
When you say good and keeping it in there, you're talking about keeping it as the title. You're talking about title, correct?
Okay. Right. Because the basic idea of a trust, right? So let's take a piece of property. Let's say I have my house in my name, right? And I die and it's supposed to go to my spouse. Well, if I'm dead, I can't sign the deed, right? Changing the title to my spouse. So if all I've got is a will or this intestate succession, I have to go to court and get the court to give me an order that I can take to the county, and that changes the title of my house to my spouse.
Probate is all about changing title.
Now, if I have a trust and I have put my house, while I'm alive, I went to the county, I recorded a deed, I said, I don't own my trust anymore. My trust owns I don't own my house anymore. Sorry, my trust owns my house. Then you don't need a probate court order because the county already knows that whoever's in charge of your trust, which would be your trustee, they've already got title. So all we have to do at that point is let the county know, all right, Mark's no longer the trustee, now Pete is. So and we don't need a court order for that.
Very good explanation, Mark. Thank you.
All right. Okay, so anybody know this guy? Let's say that we get into the court and we start processing everything and that open forum thing comes up and people come in and start making claims about all this. This is the guy in Orange County who's ultimately responsible for deciding where your assets are going to go. It's Gerald Johnston. He's the presiding judge of the Orange County Probate Council.
He's a sweetheart.
He's a really nice guy.
Really a nice guy, but he's overworked.
And he's not in the courtroom all the time. He's got other judges that work for him on the probate panel, and some of them are not as nice as he is. But it's really weird to think about. This is the person who's going to make up your decisions if you don't do it yourself. So in the rest of the series, we're going to figure out how to do it yourself. So let's go back. Just say, I can't make my medical decisions. How do I keep from going to a probate court? I do an advanced healthcare directive. That's the document that says if Mark can't make decisions about his healthcare and his body and the treatments that he needs, then the agent Mark, appoint under my healthcare directive will do it for me. I'm not worried about a court picking somebody that I don't trust with that job.
And you can pick up an advanced healthcare directive, have your attorney do it. You can pick one up from the internet, from your hospital. There's lots of places you can go to get one. There should be no excuse for not doing one.
Right. These are easy, relatively easy forms to fill out.
The next one is a little harder.
Yeah. So that issue of if I can't manage my assets, right? We talked about the court was going to appoint a conservator of my estate. I don't want that. So I to execute a durable power of attorney for assets, right? It's called a whole bunch of things, but it's generally just a durable power of attorney is what people think of it. It's durable, and durable means that if I execute it and I become incapacitated, it stays in place. My incapacity doesn't make the document ineffective.
I would not recommend you do your own because it has to do with finances. Please see an attorney. If you just, if you don't mind going to probate, you just want the advanced healthcare directive, you want the power of attorney, and you want a will, and wills go through probate, but you don't want to trust. That's perfectly okay. It's just make sure you have an attorney do it. It's probably a little lower cost, but I'm not sure.
Yeah. I mean, so California and every state has a statutory form power of attorney that comes lifted right out of the probate code and retyped onto its own form. But I would tell you that power of attorney is lacking some very crucial powers. So if you
Next week, we're going to be going through the Advanced Healthcare Directive and the powers of attorney.
okay, good. So you'll hear about
We're going
the
to spend an
statutory
hour and a
form.
half on that because
Yeah.
they're so important.
Right. So this is how you avoid the conservator of the estate, is you do your power of attorney, and it says if you become incapacitated, you have picked the person who's going to manage your assets for you,
Not the court.
not the court. Okay, can't raise your minor kids, right? So this is another way that the court can get involved and appoint someone to manage the assets for your kids or help raise them. How do you avoid that? You personally nominate the guardian of your kids, right? You can do it as part of your will. You can do it as a separate nomination form. You can do it a whole bunch of different ways, but you just say, if I die and the kid's other parent has died too, then here are the people that I want to take care of my kids.
Just have it in writing.
Right. Write it down and revisit this one a lot. Don't do it. I did it once, when I had my second kid was born, which is kind of the thing that triggers people.
Yeah.
And then we didn't really look about it for about 5 years. And then we finally were, thinking something else came up and we were looking at our documents. We looked at it and we were like, what were we thinking? That's a terrible idea, because we'd seen the person we nominated as a guardian get married, have kids. And as we watched how they were raising their kids, we're like, no, this is a bad
choice. Yeah.
Yeah. So so it's an easy thing to do, and you should revisit it regularly. So that
If you're a grandparent, it's one of the nice things to remind your children to do.
Yes.
Over Thanksgiving Day dinner.
Right. You can give them a gift card to get their nomination of conservatorship done.
I want to raise an issue, which is not a question, but someone raised their hand a minute ago. And we have no way to respond to a raised hand because one, we can't see it. And so if whoever that was that raised their hand, if you use Q&A and type the question, be happy to answer it, but otherwise we can't respond to a raised hand other than we have a hand up. Okay, thank you.
All right.
So last column here on getting away from the default system is if you have left no instructions. We've talked about what the intestate rules are. So you don't want those? Do a will. Somebody asked the question, we're going to talk about it more in a minute. Add beneficiary designations to bank accounts. Make sure your life insurance and your retirement plans have beneficiaries, and those beneficiary designations are current.
And they avoid probate beneficiary designations. They're probate avoiders.
Right. So if I tell Schwab, hey, if I don't use up all the assets in my IRA, here's my beneficiary who gets all my IRA money. Schwab doesn't have to go to court because it's a contract between me and Schwab about who's going to get my money, but it only works if I do it. And now you can add those kind of instructions to regular bank accounts, checking accounts. There's even a way to do it on property through a special kind of deed, although I
discourage it.
On that. Yeah.
It's a lot of fraud.
Yeah.
What about joint tenancy? Are you going to talk about that? I don't know if you have.
Yep. We're going to get to that in just a couple of slides.
Okay.
Yeah. So, yep. See, it's the 2 slides away. We're going to start talking about title.
No problem.
But I do want to spend a few minutes talking about the court's preference for family members. It is hugely strong. It's in the statutes, it's in case law. Courts will always push to have a spouse or a kid or some other family member put in charge of your assets and put in charge of your estate. If they have to appoint a conservator, if they have to do anything like that. And you kind of see the order. There's spouses, adult children, parents, siblings, and then nieces and nephews. Does that sound familiar? It should, because that's the same thing that we looked at as the intestate succession chain. So if you want somebody other than one of these people to be involved in your healthcare or in managing your money, you have to be very specific about it. And you need to put it in writing, and you need to when I do this, and I know that we're going outside of this family priority, I state that right in the document. We're aware of the priority under probate code, whatever, but we're choosing a different path. So I don't have a judge thinking, they were out of their minds. Why would they do that? Of course, their spouse should be in control. I want to express it very plainly and clearly, and that I've chosen somebody else. Because otherwise, if you choose your best friend, or I talked about choosing my brother in Georgia, and my spouse says, oh no, he's not doing anything. The spouse is right there in court, able to say, I think that's a crazy idea, Judge. I'm the spouse. I should do this. And the judge is going to go is going to say yes.
And by the way, and this goes for living trusts as well. So it's not just for wills or for intestate succession.
Right.
Do people complain about the way people have their estate plans?
Never. No. It's always, it seems like, when I first started doing this 26 years ago, trust contests were really pretty rare, and there wasn't this whole thing about undue influence and capacity issues. All that's really mushroomed in the last 15 years.
Right now, undue influence, elder financial abuse is the #1 crime here in Orange County. And it might be because of the property values are so high. And when someone dies, there's a substantial estate. And there's everybody's looking for a piece of the action. So, and if you haven't done it correctly, there are problems. It's not, you have to have somebody to complain. So not every estate goes to court. Just once in a while, it does happen, and it happens more often now than before.
Yeah.
Do all states have probate?
Yes.
So I can't move to a state to avoid probate? There's a lot of things I might move for, but that wouldn't be one of them.
Yeah, no, I mean, every state's going to have some intestate succession rule in place. They may call it different things, and the courts may have different names than what we have in California, but they've all got the same kind of
changing titles. Each state controls the property in its state.
Okay. And just as a note, 20 minutes.
All right, I'm going on. All right, so here's some alternatives. Let's just see. So I think we've got 4 or 5 more slides. So some probate alternatives to consider, because Pete just said, if you just want to have a will, or you just want to have the power of attorney and you don't want to go through the trust plan, that's perfectly fine. But think of some of these other things that will help you avoid probate. The #1 is these pay on death provisions. Didn't really exist 15 years ago, except on retirement plans and life insurance policies. And then banks started letting you add them, credit unions started letting you add them, investment houses started letting you add them. So you can now go account by account, put a pay on death transfer on there, assuming the financial institution has that option for you.
So you would go to your bank teller and say, on my checking account, please put my daughter or my son on that account. And then what does the daughter or son have to do once the person dies?
Take a death certificate into the branch and say, I'm listed as the beneficiary on this account. Here's a death certificate, and you leave with a new account or a check or something like that that you control.
Yeah. Would you recommend people do that for their entire estate?
No, I think it's good for, I mean, you certainly could do it if you were very.
Oh no,
careful.
I've met people who have done it. $3 million.
Yeah.
It was a full-time job for them to keep track of their paid on death accounts. But
right.
Would you normally recommend it for an account maybe less than 100,000?
No, I mean, because we do have that $184,000 ceiling. So, if your assets that don't have a clear line to another person are under that $184,000, then you don't need to do it. Pay on death provisions are odd because not every institution allows them. And a lot of times, once a pay on death provision gets to be 5-6 years old, I've seen organizations question them and say, we're not going to do it. It was too long ago. So pay on death transfers can be really effective. But like you said, you've got to monitor it and you've
Yeah.
got to stay up with it.
Beneficiary designations, are you normally talking about insurance, IRAs, 401ks and the like?
Exactly. Yep. So all of those types of accounts where somebody else has physical custody of the assets, and they want you to tell them who is this supposed to go to when you're gone. You do it through, through beneficiary designation.
And this is such an important area. We're spending an hour and a half on beneficiary designations, especially retirement plans. So I don't want to spend too much time on that today. What about rights of survivorship, joint tenancy, and what does CPWROS mean?
That's just one of those things that attorneys like to throw around to sound WROS means with right of survivorship. So it's basically saying, and the CP is community property. So a right of survivorship says, if I own a piece of property and I own it with five other people, and we have rights of survivorship, that's usually joint tenancy is the way we think about it today. So I have assets in a joint tenancy with other people. As people die off, their interest is extinguished. And the last person standing, the last person alive ends up with title to that joint tenancy asset.
And the joint tenancy asset, does that trump a trust?
It does. Your joint tenancy happens by operation of law. So you've already said it, you've created title in a way, and in California, rights of survivorship and joint tenancy don't go through probate. Luckily, those assets aren't subject to creditors because it's because the fallacy of joint tenancy is that if five of us own this asset, or I own it with my two kids, then the three of us we each own 100% of the asset, and we're just waiting to see who's the last person alive.
What if I become demented or have a stroke and I have the property in joint tenancy? What happens in those circumstances? How do we transfer that property?
You're stuck. If you've become incapacitated mentally, you don't have what the state of California calls the capacity to make a contract because of your dementia or whatever it is. You're stuck.
What about income taxes? I know that community property gets a full step up in basis on death. Does joint tenancy legally, technically?
No. I don't think we have a slide on that, but what Pete's talking about is a very good point, because community property, especially in California, has this unique feature. So let's say that I own my house with my spouse, Dr. Seuss, and we have community property with rights of survivorship, that's CPWROS, right? So we have a deed that says this property is our community property. Then when I die, if I'm the first one to die, the tax rules say that anything that people get as a result of my death, their income tax basis is the fair market value on the date of my death. So I'll take a client in Emerald Bay who bought a house in Emerald Bay many, many years ago for like $60,000, and now it's worth about $9 million, right? So they owned it, the husband and wife owned it as community property. When this husband died first, all of the gain, so they paid about $70,000 for it. So all of the gain from $70,000 to $9 million was washed away. So the surviving spouse could sell it the next day, go live somewhere else if didn't want to live in that house anymore, without any income tax being owed, without any capital gain being owed. So that's Pete's question, and that's
title. It's just so important. Do not listen to real estate agents about how to put property in title. If title is just huge. It tells you what document that gives you legal authority to act, if you can act. Joint tenancy is really a trap for most married couples.
Yeah, because Because what happens there is, that so let's say we own my house, joint tenancy and community property between spouses, we can kind of think of them the same way. So if you have your house and it's in joint tenancy and it's going to pass to your spouse on your death, that's an easy thing. We didn't go through probate. We didn't have all that paperwork to do. We just took the death certificate, sent it to the county with an affidavit to change and get the husband's name off. Because so now it's just wife's. She can sell it the next day and pay no capital gains on it. So community property is something that estate planners talk about. It's a family law concept. And when you're talking to estate planners, some of them, will say, okay, we need to get a family lawyer to sort of weigh in on these issues because it's a crossover point.
Yeah.
I'm going to tell you that you got about 5 minutes because we've got some questions that we also need to cover. So. just
Okay.
let you
Okay.
know.
All right. So.
Speed it up.
Yeah. Okay, so I'm just looking at what we have. All right, so execute a will. This is the one thing that you can do. There's 4 types of wills, really only 3. One you write out by hand. That's the back of the napkin at the bar, right? That's a holographic will.
And it's valid.
It's valid. You just have to say, I know I'm giving away my assets. I know this is going to be effective at death, and here's what I want. Sign it on the napkin. It's done. No witnesses, nothing.
Statutory.
That is a form that you can pull off of the Attorney General's website. It comes right out of the probate code.
Just plug in Google California statutory will, it'll pop it up. What is a
Yep.
formal will?
Formal is when you get an attorney to do it.
That's the way it should be done.
That's the way to do it. Yeah, because
And
the
what is a
statutory
pour?
will has
Yeah.
the
What
statutory
is a
will has
pour over
whole.
will? I want to get a pour over will. Pour over will.
Yeah, so pour over will is the type of will you do when you have a trust and you want your trust to be your primary document. Your pour over will just says, if I didn't get something titled in the name of my trust during my life, then I want that done at my death. So it just pours it over into the trust.
Okay. I love the line. You're telling it how you want to distribute your assets. That's what a will is about. It does not avoid probate. Next slide.
How to avoid probate. All right. So we have to keep in mind that there is a probate estate and a taxable estate, and people talk about them and it's not always clear. Your probate estate is the group of assets that there's no way to change title without getting a court order to it. And so that's all the stuff we've been talking about so far.
So if you have property titled in your own name and you die and
Part of
you
my
have no
probate.
will or trust, that is a probatable asset. So
Right.
what we recommend highly is take your assets, put the title that you have to that asset, put cost basis, put market value. It's in the workbook that Dawn has prepared. Take a look at it. It's really, really helpful.
Yeah.
What are the common methods of holding title here?
In California, okay, so the common methods.
Is to hold it in a revocable trust.
Yeah, exactly. So we talked about joint tenancy, we talked about community property, separate property. In California, I'm going to bet that 90% of the estate planning work that gets done involves a trust,
Yes.
because it's the one way to avoid probate.
It's a
And we already
way to
talked
hold title.
Yeah. So like we talked about my house a little bit earlier. If I take Mark Powell, owns it as an individual, and I change my deed and I say Mark Powell, trustee of the Mark Powell Trust, owns this house, then I don't have to go to probate when I die because the county already knows. And you can do that with every kind of asset where you tell a bank about your trust, you tell your investment people about your trust, they do the paperwork so that it's titled in the trust. When you die, you just change and say who's the next new trustee.
And we're going to spend an hour and a half on a living trust.
Okay, good. That'll be good. So real fast, avoiding probate, always review things. Never just do a document, put it up on the shelf and think you're done. Life changes, your assets change, the people that you want involved change. You need to review it all the time. You need to have your personal financial statement. Look at it, understand what you own, and understand how you own it. Back to Pete's issue on title. And then find an attorney who will do these things with you.
Super.
So very last, if we have, do we have 2 more minutes to
Well,
talk?
yeah, we're going to cover this in the trust section. I want to save a little bit of time for Dawn. You want to come back on and go ahead and do away with her. By the way, Mark has his address and phone number and email at the end of, yeah,
Right there.
you go.
Okay,
Yeah.
so let's leave that up for right now. We'll get rid of it in just a minute, but okay, we have a series of interesting questions, I think. And if a person or a couple has exact equal residence, property, etc., in 2 states, what state takes precedent?
So real estate is going to, the courts in that state are going to have to control the real estate in there. So if you've got equal and, parts in California and parts in Nevada, then you're going to end up having to get a Nevada court involved if you go through probate, because real estate in that state has to be handled by a court in that state. But
How do you avoid that?
Man, do a trust. Yeah.
Okay. So next question is, and it's a follow-up to one that I had answered earlier, but I just want to make sure that we're in line with it. So I have a friend who thinks that I should be the executor of the estate, but haven't told me that. Put it into their documents that I am going to be the executor, and they die, and now it says I'm the executor. I don't have to accept the position.
No.
Do I have to do anything to prove that I didn't accept it?
There will be some so somebody needs to, if that's in probate, right? Because you're talking about an executor, so that sounds like a will, and you're going.
I'm sorry. Let's something that it could be either way, because it could be trustee, a guardian, any of those things, any of these things that someone's appointed me.
So any of those things, you can say, I do not want this job. And all you have to do is one way or another sign something that says, I know I've been given this job, I decline to take it. Sign
All free.
Yeah, and that's it. And the lawyers will couch it in different terms, but that's it. You just have to say, I don't want the job.
Highly recommend that you allow your successor trustee or executor to recommend someone.
Yeah. So, right. So if I name Pete and he says, I don't want to do it, then who's going to do it? Well, I could name successors to Pete, or I could say, well, Pete, you pick somebody,
Yeah.
at that time. One point on that, if I can,
Yes, please.
if you don't want to have that job, do not do anything that looks like you've taken the job.
Yeah. Yes. Yeah. Don't act like you were and then change your mind. No, that's different.
Right. Don't go to a bank. Don't talk to the lawyer. Don't talk to the beneficiaries. You need to have clean hands and just walk away.
Okay. So if the spouse has a pay on death provision, but the spouse has more than half the estate listed on pay on death to a non-spouse, what happens?
Depends on if it's community property assets or community property assets. If it's a community property, and let's just say everything is community property because we're in California, so chances are it's community property. You can control your 50% of the community property, but if you give it to anybody other than the spouse, your spouse, that spouse who's not going to get it anymore, has to consent.
Okay. Incidentally, turn off your screen. Sure.
Oh.
Just because they like it if we do this at the end where it's actually our pictures. There you go.
Okay.
Okay, last one, and it's one that's come up with before. A holographic will. Do I have to write it? Why can't I type it and sign it?
Very good question. You can type it and sign it, but that's not a holographic will. A holographic will is specifically handwritten. And so to qualify to be a holographic will, it has to be handwritten 100%. It can't even be a mix.
In their handwriting.
Yeah, so you can't have one that's typed and then go back and scratch out things and handwrite on it. The court won't accept that. They won't know what to do with that. So holographic has to be in handwriting. Otherwise, the statutory will is a printed form. It's the only one that allows you to write on it, and that's provided specifically by the statute.
By the way, the holographic will is the most litigated
Oh, I'm sure.
form
yeah.
of a will.
Right,
And then
yeah.
the second one is the statutory will is the most litigated. So,
Yeah.
you know, keep that, they're good for small estates, for naming guardianships, I think, you know, for a young couple. But if you have any substantial estate, think of it as protecting that estate for during your life. I just want to go back to that. It's about while you're living. If in the event you get dementia or Alzheimer's or a stroke, who's going to be there to take care of you?
There's one last question. It relates to the holographic, and I think to Pete's point, it really goes back to litigation. How does the court know their handwriting?
You know, it's a good question.
If nobody protests, it is. If
If
someone
nobody
protests, it
argues
isn't.
about it, yep, you're fine. If somebody argues about it, well, I can't
You
say.
gotta
it.
show
You're up a
You're-
creek. Yes.
You're up a
And
creek.
and to Pete's point, that's part of why you would wind up in litigation over it is, I don't agree that mom really wrote that.
Yeah,
Right.
or you say, I want the security to go to X. Well,
Right.
is a bond a security or not? I mean, the
Yeah.
terminology it becomes, that's why you have case law as
Right.
to how to.
That's why we have
define-
attorneys and why they make a lot of money.
Correct.
So
As
we
a-
have this-
Holograph, I will leave one comment
Please.
on holographic wills.
Yes,
The reason I think they are so problematic is that they're usually done in a rush at a bad time. So they're done when you're in a hospital, right, and you're on medication, or they're done when you're at a bar and you're soused.
and you're mad at
When I
something.
ask
Yes,
most
yes.
of my friends to write one is when we're at a
Right,
bar.
And so your signature doesn't look like your normal signature, and all
Right.
somebody has to do is bring in a handwriting person to say, nope, that doesn't look like the signature, and it's all it's all gone.
Right.
You're stuck.
Yeah.
Any other
Obviously-
questions, Don?
No, we're good. So this has been financial estate literacy. This is week 1 overview of It's Your Estate. Clearly, we're going to talk about all of these pieces in greater depth as we go through. I've deferred a couple of questions. And Mark, thank you very much for joining us from Canada.
Glad to.
We appreciate the internet and your ability to be here. Pete, it's been fun.
Yes.
Next week, we will continue this. And
Next week,
as-
we'll do the durable power of attorney and we'll do the advanced healthcare directive and just touch on the conservatorship, because if you don't, you end up being there.
And since I did remember to turn the video back on, the video will be up within the week, hopefully, and we will do that. And again, thank you very much, Mark and Pete. I'll see you in Laguna. Hi, Hallie.
Bye. Bye, Haley.
Bye.
Bye, Mark.
Bye, everyone.
Bye.